there, happy Sunday. I thought I would hop on to answer. I got one question that I did not get to answer, and then I thought I would touch on the adjustment of status versus the consular processing. So these are two topics I'm going to be talking about. But of course, this is about you. If you have any particular questions that you would like to ask, please go ahead and drop your questions in the comment box, and I'll stop talking about the topic I'm presenting you today and answer your particular questions. Just keep in mind that this will be general immigration information based on the law and what's going on right now, and not personal legal advice. If you would like personal legal advice, just go ahead and give my office a call at 561-405-4889, and we can schedule a consultation with you, get you on my calendar, and I can go through your particular situation in detail and give you more accurate legal advice. So, the first thing I want to do is address that question that came in yesterday about unauthorized work. So, I believe the situation was the individual came into the United States on a visitor's visa and worked without authorization, and then the visa was revoked for that reason. And so, how is this going to affect her future prospect for a green card? And so they do look at this and treat it very harshly. And unauthorized work in the United States means that the officer could potentially deny any future applications, and generally, an individual is barred from adjusting status if they have unauthorized work, except for certain circumstances. So in this case, there's also the fact that one can be charged with misrepresentation and for basically taking a non-immigrant visa where it didn't authorize work, and saying, and basically saying by taking that visa that they will not work, and then by violating that the terms of the agreement, or by stating in a future visa application or on any documents that they did not work, and then it was discovered later that they did work, that could lead to a charge of misrepresentation, which is causes further inadmissibility, meaning that one would not qualify for any visas or a green card unless a waiver applied. So there are exceptions for this. So I believe the question was, would they still be able to get their work authorization in the United States? And it really depends on the severity of the circumstances. So is there a misrepresentation that was attached to it? Are they already in the United States? And if not, chances are the officer is going to view that negatively and deny any future non-immigrant visas just because of the violation of the terms of the visa, the history of that. In certain cases, if an individual is in the United States, they can get around being barred from adjustment of status. That's basically applying for a green card from within the US. And that's if you are the relative of an immediate, of a US citizen, or if you are applying for VAWA. And also, there is forgiveness for unauthorized work, and that goes to individuals who are adjusting status to obtain an employment based visa, and they worked for less, they did the unauthorized work for less than 180 days. So it's very specific. If you would like specific legal advice, further evaluation to determine whether you will qualify for any forgiveness in the future, or how severe your bar could be, give me a call at 561-405-4889 and schedule a consultation. And then we can talk about it further, and I can go through the details to see what happened in your case and what to expect going forward and what you can do to solve your particular issue. So let's talk about the adjustment of status process versus the consular processing. So that is, if you are applying for a green card and you're in the United States, you would like to stay in the United States, then the adjustment of status process should be what you look for. So the adjustment of status, oh, I'm sorry. Hey, hi, Urena. How are you doing? It's good to see you on here. So, so the adjustment of status process is where you are here in the United States and you want to stay here while you're applying for the green card. Now, keep in mind that the you must qualify for the adjustment of status process. It's very specific. So you want to make sure that you fall within the criteria to qualify. If not, then you're going to have to go with consular processing. So, for one very important aspect is that you must be continue to maintain your legal status in the United States to move from one status to the other. So you can't fall out of your employment based um, visa status and then adjust status unless there are certain exceptions. So if you are the relative of a U.S. citizen. So I have a question here, Urena. Um, Yes, definitely. So during the T visa and the U visa, so the U visa is based on if you're a victim of a crime, and the T visa is based on if you were coerced into coming to the United States, or you were forced to come to the United States, or you are already in the United States and you were forced to do work or to do acts that you were against your will, then those would qualify you for a T or a U visa. And what happens is when you submit the application, then for example, the U visa, it takes some time, so it is taking many years. And what they are doing now is they are providing deferred action, meaning that they are saying they're not going to take any action to deport you or do anything like that, enforce any kind of immigration laws against you. And once you're in the deferred action for the U visa, you can apply for work authorization. And they're doing that because it's taking so long to actually get the U visa. And then the T visa, there is no current wait list right now for the T visa, but the same applies. You apply for the T visa and then you can get the work authorization while the process is pending. Once the U or the T visa they're approved, then you get a you don't have to keep renewing the work authorization, say every year. You would have work authorization for 4 years. And then once you live in the United States on the T or the U visa, it actually allows you after 3 years to adjust status to a green card. So it's a long haul, of course, but if this is something that happened to you where you were the victim of a crime or you were coerced, forced to do work, or somebody took advantage of your undocumented status and made you do things that were against your will, like work or commit sex acts, commercial sex acts, then this would definitely be what I would I would recommend you look further into. And you can call my office at 561-405-4889 to schedule a consultation to evaluate your particular situation, make sure you qualify, and get started on that visa ASAP. But yes, so the short answer, Urena, is yes. Um, there is a work permit during the process that's allowed right now, and especially for the U visa where it's taking very long, they put you in deferred action, and then that's where you can get the work permit while your application is pending. Thank you for that question. So, yes, so back to the adjustment of status, just make sure you qualify relatives of US citizens or US citizens, immediate relatives of US citizens. So that's the spouse, that's a child who is under 21 or a parent can qualify for the adjustment of status process if they have no status. So even if they've been here and they've been living here without legal status, that is an exception where they don't have to maintain their status. They can adjust status without it, and that unlawful presence wouldn't be held against them. No problem. I'm looking forward to hearing from you. So, so it's very important to check that out. Make sure that make sure, see if you can fall under an exception. And if not, another exception is a VAWA. So the VAWA applicant can stay here in the United States without status and complete the green card process without their status. And even if there's a previous deportation, that can be overcome. Even if there's an inadmissibility in the case of a VAWA applicant, they can still stay in the United States and apply for a waiver. So, for example, if there's a criminal issue, then they can apply for a waiver. But when there's unlawful presence or unlawful entry, a VAWA applicant can easily overcome those. So they do fall under an exception and they're not barred from adjustment of status. I just want to reiterate, just like Urena had asked the question while I was talking, please go ahead and drop your questions in the comment box and I will answer stop what I'm doing, answer your question as they come in. Right now I'm talking about two processes to get the green card, and it's the adjustment of status process where you can stay in the United States, apply for the green card under very specific circumstances, or you can also complete the process in your home country. So if you don't qualify for adjustment of status, there is also the consular processing. Now, if you've been here with unlawful presence, that means that you've been living here without your papers, without legal status. So basically, you're in violation of you're in violation of immigration laws. You either entered illegally or you have an overstay, you don't qualify as an immediate relative of a US citizen, then chances are, and you don't qualify for VAWA or you don't qualify for any other form of relief that allows you to stay in the US, then you will need to do consular processing. However, if you're here with unlawful presence, you want to make sure that you look into the waiver, the unlawful presence waiver. You can stay in the United States, apply for the provisional unlawful presence waiver, and wait to see if it's going to be approved. And then if it is approved, then you can take that waiver, that approved waiver, go to the interview. So when your interview is scheduled, you can fly out, go to the interview in your home country at the US Embassy and attend the interview, and know that the officer will not and is not supposed to be used the unlawful presence that you've just been forgiven for in the waiver against you. So you would not be barred or stuck in the country based on that unlawful presence. That's what that waiver does. So you want to make sure that you look into that waiver if you don't qualify for any other form of relief. Now, I want to talk about the process, the step-by-step process. So under the adjustment of status process, you would submit the application. Usually what would happen is you would submit two applications, a petition that's based on your qualifying relationship with your relative or your employer. And then you would attach the I-485 form, and that's the actual adjustment of status application that's saying, asking for permission to stay in the United States and get your green card here. So for them to complete the process here. Now, if you would like to work here or travel for some reason, while during the process, you would also submit your I-765 form. That's the employment authorization application, along with an advanced parole application, the I-131 form. And once those go in and they're accepted, you want to make sure you send it to the right office, you submit the right fee, you complete the form correctly, and you attach the right evidence. Once the office, the USCIS office accepts the application, you'll get a receipt notice. And then after the receipt notice, about a few weeks later, you will receive an appointment letter for a fingerprinting appointment. That fingerprinting appointment allows them to do a background check during the process. Now, after the fingerprint, it's a very brief appointment. If it's not too crowded and you don't have lines, it could be as short as 15 minutes. So, definitely nothing to worry about. You're not going to be interviewed. You're not going to be asked any difficult questions or placed on the spot. It is just a routine fingerprinting appointment. Then after that, you should receive, or usually you receive, your work authorization in the mail and your travel document if you applied for those with the initial paperwork. That comes about 4 to 6 months after the initial application. Now, there may be hiccups along the way, so you may get things like a request for evidence if there's something missing that the officer feels like they need to make a decision, or they need to complete the processing of your application. You may get that in between everything. If you don't get that, then chances are the last step would be the interview. So after the biometrics appointment, nothing happens, which is great. You're just waiting. The final step would be to wait for that appointment letter to come in the mail. And the appointment letter, once you get that appointment, you attend the final interview where the officer is going to ask you questions to confirm that you indeed qualify for the green card based on employment or based on your family relationship. And usually even if the officer will tell you, or you will get the vibe that yes, you've been approved, or the officer will ask you for more information and let you know, either give you on the spot or send you further a request for further information in the mail after the interview. And then hopefully some weeks after, you'll get the green card in the mail if it's approved. So that is the adjustment of status process in the United States in a nutshell and generally. The consular processing is you'd submit usually your employer or your family member would submit the petition first. And then once that's approved, hopefully it is sent to the National Visa Center. The National Visa Center will get in touch with you and ask you for all the documentation that the embassy will need to complete the process. Once you send that, I can't stress enough that I noticed that at the National Visa Center is where everything gets delayed, because when the National Visa Center sends that list of documents, for example, in the family immigration area, once they ask for the affidavit of support and other civil documents, the clients will procrastinate because sometimes it's overwhelming. There's a lot of documents on the list. what I do, my strategy is I have a list of those documents beforehand. I know exactly what the embassy is going to require. And I give my clients that list way before the National Visa Center asks for it. And then I keep those documents. So as soon as the National Visa Center gets in touch, I just send those documents out, and that reduces delay. So the faster the NVC gets your the NVC is a National Visa Center. The faster they get your documents that they've requested and get the fee payments, because there's going to be a visa fee payment for the immigrant visa. Even though you're applying for a green card, you're issued an immigrant visa, and then once you come to the US, you become a permanent resident. So it's called the immigrant visa application fee, and then the affidavit of support fee in family immigration. So you have to pay those fees as well as supply the required documents at the NVC request. Once those are in, the NVC will send a letter saying everything is complete and it has been sent to the embassy to be scheduled for an interview. And then some weeks to a few months afterwards, you will get an appointment letter with the date and time and place for your interview. You'll also get instructions on how to complete a medical examination and to get your police report. Those are things that you usually have to get done a month to 2 weeks before your interview. It just depends on how much advance notice you get on the date of the appointment. But the medical exam is usually a specific doctor that is so you can't go to your regular family physician unless that doctor is one that has been authorized to do the medical examination. So you have to look to make sure that you are looking at the list of doctors authorized to do the medical exam. And once you go in, they will know what to do. They carry out the physical exam, they'll do blood work. Usually, blood work includes the drug tests and tests for certain illnesses. And the doctor will ask you certain questions regarding maybe your mental state or your background. So that is the medical exam. And then the police report is basically a background check, and is certified by the specific police department. And so you have to go to a specific, usually each country has a specific agency that does this. So you have to look to see who issues these police certificates. Once you get that together, you attend the interview. The officer is going to ask you certain questions based on the reason you're applying. So if it's employment based, it's going to be, your qualifications, your background, to make sure that you don't have any inadmissibility issues, like criminal issues, for example, that would prevent you from being admitted to the United States. If it's based on a family relationship, it's going to be questions based on your marriage to make sure that it's a real bona fide marriage. So, how did you meet? Where did you meet? How did you get engaged? They will ask you, what's your spouse's birthday? What's your anniversary? To make sure that this comes to you very easily. So I have another question here. So what if the police report is no longer available? What happens next for the U visa? Okay, so the U visa is different. The U visa is a different process because you're staying in the United States. So they're not going to be seeking any police report in your home country. That is something that is done if we're doing consular processing, meaning the person is in their home country and they're doing the process there. So the U visa is not, and it's not a green card. So the U visa is a non-immigrant visa that allows you to live here for 4 years. And then after 3 of those years, you can apply to get your green card. You can adjust status in the United States. Now, if you were a U visa, now with adjustment of status process, I have never had to request a police report from the country during. So if you, when or if or you do obtain the U visa status, and then you've met all the requirements and you're ready to adjust status to a green card holder while being in the United States. I've never had the issue where I've had to ask for a police report. Now, if you have a criminal background in the country, then that is a different story. You would definitely have to get those records from the country. And every country has them. So every country has an agency that releases a police report. And that police report would be something like, you have no criminal record. They have no record of your. So even if you had to request one, almost every country has an agency that will issue a police report or a police certificate. Um, the police report now, in the case, now another thing is, if you're talking about the U visa in the case of a police report, so I may have gotten it confused here. So the police report, if there's no police report, then the most important part of the U visa. So let me get back to basics. The U visa is for victims of certain qualifying crimes in the United States, and that does include domestic violence. And so domestic violence, assault, um, kidnapping, and that is not an exclusive list. It could be a crime that causes you mental and physical trauma. So it's flexible. Now, if there is no report, usually the police department will issue. This is the most important part of the U visa requirements, is certification, and the certification will is basically the police department or the law enforcement agency. Could be the prosecuting attorney, could be the police department. They would certify that this occurred, that the individual, the applicant, was the victim of the crime and they cooperated in this case. So, and if a police report isn't available, usually that I mean, the police certification would be one way to show that this did occur, or the police would be able to attest to the fact that this crime did occur. So if they can't provide a police report, then that we could definitely, this is something I would request from the police department, is that they write a letter stating this did occur. Right. So exactly. So with the police report, usually with a U visa, they must certify that this occurred, and that's the most important. It's called a U visa certification. That is what the most important aspect. And the police would also, what I usually do is request that they write a letter stating what happened. There are also, if there's other evidence of the crime, like court records, then that would be another way. A court records, a restraining order in the case of domestic violence, as you said. So court order, restraining order. Those are also evidence of the crime, but the U visa certification, that is a certification from law enforcement saying that yes, this occurred, yes, that the applicant, it was a victim of the crime and they did cooperate in the investigation. That's the most important part, and that is something I do. I follow up with the law enforcement agencies to produce that certification. So that is something that is done during the U visa preparation. That's a great question. Thank you for that. So I believe that's it that I have for today. I'm definitely going to be here as usual Fridays at 6:30, but I really like to keep up with you and come hop on when I can to give you a chance to ask your nagging immigration questions, because I know everybody has them. Um, Okay, so no problem, because I try to get mine, but they said the person did the classes, so that was removed in the system. Okay, so yes, I guess, and in that case, it's probably because they are keeping it sealed because there's maybe through the process, but that is because of they went through the criminal justice process, but that is where the U visa certification would come in because the police would then attest to the fact that this occurred and then and basically certify that yes, you were the victim in this case. So what I would say is I make everything very easy for applicants. I do the hard stuff. I do the digging. I follow up with law enforcement. So definitely, no worries. Just get in touch with me at 561-405-4889. Once I get started on your case, once I determine you qualify, once I get started on your case, I take care of the difficult stuff and the challenges in your case to put together the right evidence. So no worries. All right. Thank you, Urena, for all your questions. These are great questions for anybody who's going through this situation to let you know, first of all, as a victim of a crime in the US, certain qualifying crimes. But I like to say if you're a victim of a crime, see if you qualify for this. And even though the wait is very long, if it is something that is your last resort option, that is something I can let you know. I can look at your other options, but this could be a last resort option for you if you are undocumented in the United States. So thank you. Those questions and these questions shed light on the challenging aspects of the U visa process. So thank you, and I will be back again. So I hope to see you soon. All right, bye, guys.